Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sankara. This video relates to the point whether the lawyer promises that he would win the case but he fails, then if it amounts to cheating or not. If he takes money, whether it amounts to breach of trust or not. These are the points which we are going to discuss in this video. Please remember, the judgment is of 2022, but it is useful both for the Law of Torts, Consumer Protection Act as well as ethics students. 3 subjects are involved: ethics, Law of Torts as well as the Consumer Protection Act. And you have to know these points. In the case of S.Mahadevan versus Cyprian Menenzez, Cyprian, Cyprian Menenzez, Menenzes, and another 2022 case, WP number 54069 by 2017. On 9/9/2022, Justice Suraj Govindaraj of Karnataka High Court held that the client cannot file a cheating case against the advocates merely because the court passed an unfavorable order, even though lawyer said he will win the case. It is for the court to decide the matter. You have to agree, is it not? Even though you argue very beautifully before the court, it will not be successful because of so many things. Right. The allegations are Mr. S.Mahadevan is an advocate. He told the client, that is Cyprian Menenzez of Mangalore, that he would represent them in Bangalore cases. He would consult a lawyer at Supreme Court and he will also attend the court, because advocate on record will be somebody of the Supreme Court and he will attend the court also. Ultimately, the result is that he will definitely, Menenzes will get a favorable order. That means advocate will see that a favorable order comes. But time is going on. Time is passing on. On the particular day, the matter was posted in the Supreme Court, and on 18/4/2016, when the matter was posted in the Supreme Court, and after the court hours, when the Cyprian Menenzez asked the advocate S.Mahadevan about the result of the case, he did not give a proper reply, and the complainant, that is Menenzes, came to know that the advocate did not respond properly, he did not represent properly. The matter has been being posted for consideration for the past 2 or 3 adjournments because of the non-appearance of the other respondent. This man doesn't know it. Menenzes does not know it. He is under the impression that he will get some favorable order, but even after 3 adjournments, nothing of that came to light. Therefore, even though he spent 14.60 lakhs as fees towards the advocate, nothing materialized. Therefore, he has filed a private complaint before JFCM Mangalore, because Cyprian Menenzes is from Mangalore. He filed a private complaint. It was taken on file. Now, the advocate came to the Karnataka High Court to get it quashed under Section 482C IPC. Quashment. Why? Advocate says, yes, there is a material in this case, Menenzes case. I thought I would have won. I represented the matter to the Supreme Court. I attended the court on all the dates of hearing. But it is for the court to decide. I may not get a favorable one. It is not my mistake. As regards the fees, yes, he has agreed and he has paid it in installments, not once. He did not pay once. Like that, he argued. So now Mahadevan says, as an advocate, he discharged his duties. He appeared as a counsel before the apex court. It is only an effort to get the favorable orders. It is only in his endeavor to get the favorable orders. So it can't be an offense for not getting a favorable order. That too, the client cannot go for section 406 and 420 IPC. 406 is breach of trust and 420 is cheating. Of course, here the important point comes. Friends, already I told you that be honest towards the client. Tell him that this is the situation. They may not win. But if you say that we will definitely win, we will definitely get some favor order. If you don't get it, then matter will be like this only. That's why while discussing the very important topic, that is 7 lumps of advocacy, I told you that be honest to the client. And whenever you feel that judgment may not be in your favor, definitely explain him. So now the Honorable Kerala High Court, they clearly stated that, Karnataka High Court, they stated that matter shows, that means the record says the advocate promised the respondent that he would introduce an advocate in Delhi and that he would also appear. But no advocate says that he cannot obtain favorable order. Normally, this is the tendency of the advocates. It is all for the litigants to note that advocate can make best efforts to get the orders, but the outcome depends on the facts and the applicable law. రామ్జేత్ మలానీ వచ్చినంత మాత్రాన, కపిల్ సిబాల్ వచ్చినంత మాత్రాన, లేకపోతే చంద్రబాబు నాయుడు కేసులో సిద్ధార్థ లూథ్రా వచ్చినంత మాత్రాన ఫేవరబుల్ ఆర్డర్స్ వస్తాయి అనుకుంటే ఎట్లా? నాట్ పాసిబుల్. సో ది అవుట్కమ్ డిపెండ్స్ ఆన్ ద ఫ్యాక్ట్స్ అండ్ ఆల్సో అప్లికబుల్ లా. సో దిస్ private case is nothing but an abuse of the process of law. So therefore, the private complaint which is pending before the GFC Mangalore is hereby quashed under section 482. Luckily, the advocate is safe. Ethics prakaram, now you have to remember that కేసు నీకే ఉందిలే ఫేవరబుల్ ఆర్డర్ తెస్తానని నేను ట్రై చేస్తానని చెప్పాలి కానీ తెస్తానని చెప్పకూడదు. రెండవది, ఈ సర్వీసెస్ మీద నెక్స్ట్ ఇంకో వీడియో కూడా చేయబోతున్నాను. కన్జ్యూమర్ యాక్ట్ అప్లై కాదు. రైట్. మూడోది, లాయర్ మే ట్రై హిజ్ బెస్ట్ బట్ ద రిజల్ట్ ఈజ్ ఆన్ ది డిస్క్రిప్షన్ ఆఫ్ ద జడ్జ్. ఈ మూడు తెలుసుకోవాలి మీరు. దీనికోసం ఎథిక్స్ స్టూడెంట్స్ కూడా ఇది ఉపయోగపడుతుంది కాబట్టి వీడియో చూశాను. సో ఐ విల్ స్టే బ్యాక్. థ్యాంక్ యూ వెరీ మచ్.